Welcome to the Colorado Department of Labor and Employment's Compliance Quarterly Webinar. We will begin shortly. I'm going to wait for either my moderator or Danielle, our tech support. Can you drop into the chat for the panelists when we are ready to begin?
We're good to begin.
Excellent. Well, good morning. Thank you again for joining us. I'm Cher Hovland. I'm the Deputy Executive Director and Chief Communications Officer for the Colorado Department of Labor and Employment. We are excited to once again bring to you our Compliance Quarterly series. We started this series last year as a way to bring to our business and employer community regulatory updates from some of our divisions in the Department of Labor and Employment. As a reminder, a newsletter version of this webinar is delivered to our stakeholders the first month of each quarter. The next newsletter will arrive in October, and we'll have another webinar in November. So again, thank you for joining us here today. Before I introduce our division leadership and turn it over to our experts, a few housekeeping items. If you can please, if you have questions, add them to the Q&A. For those folks joining us via the live stream, if you can add your questions into the comment section, that would be great. A recorded version of this webinar will be available later this week at cdle.colorado.gov. And then we will certainly leave a lot of time at the end to take questions from each of you. We want this to be engaging and interactive, and so between the division leadership and our subject matter experts, we hope to cover all of the questions that you may have for us today. So with that, I'm going to quickly intro some of our division leadership before I send it over to our Division Director for Family. We have Tracy Marshall, Division Director for our Family and Medical Leave Insurance Division, known as Family. We have Paul Torriello, Director of Workers' Comp. We have Phil Spessart, Director of Unemployment Insurance. And we have Christina Rosette she is the Acting Director of Division of Labor Standards and Statistics. We do not have Division of Oil and Public Safety here today, but I will provide a quick overview of what they're up to and happy to take any questions that you might have for that regulatory division. So with that, I am going to turn it over to Tracy Marshall.
Thank you so much, Cher, and good morning. As a reminder about what the Family Division does, we were approved by voters in 2020, and we're here to ensure that Colorado workers have access to paid family and medical leave during those critical life events that pull them away from work. Family is a social insurance program, and both employers and employees contribute to the fund that does pay out those benefits. We provide up to 12 weeks of partial wage replacement when individual employees are out on leave to care for a family member, to welcome a new child to their household, if they have their own serious health condition, and it's also available for anyone who is impacted by intimate partner violence or domestic assault, and also to prepare ahead of a loved one's military deployment. As far as what's happening in the upcoming quarter, reminder for you all that rules were adopted in November of 2024 and will become effective on January 1st of 2025. They dictated that our employer entities with multiple branches that have different FEIN numbers are considered by the division to be separate employers with separate rights and obligations. What that means for you is that all members must register a family account for each separate FEIN. Professional employer organizations, PEOs, you must report wages under the family ID assigned to each member employer. Those employers that have 9 or fewer employees must register as soon as possible to ensure proper federal taxation of family benefits for their employees. Recent guidance from the IRS does state that if an employee takes leave to care for their own serious health condition, the taxation rate of those benefits depends on the headcount of the employer. For self-employed individuals who are voluntarily participating in family, you must upload your prior year's tax receipts and W-2s by December 1st of 2025. Individuals should request their tax transcripts and W-2 forms by visiting the Get Your Tax Records and Transcripts page on the IRS's website. If the tax transcript and W-2 have not been shared with family by December 1st, 2025, My Family Plus employer will automatically set the account eligibility to null, which means that individual will not be getting approved for family benefit payments. Self-employed individuals will soon be asked to confirm their account is registered under their full legal name, not their business entity name. That's because family registration for self-employed individuals covers them personally, not their business. On August 20th, which is today, self-employed accounts will be receiving a new task to confirm or provide that legal name. If a self-employed account works with a third-party administrator, a TPA, that TPA will also be informed of this change so they can help support their self-employed clients. But again, only those self-employed individuals can complete this task through their account portal. Family has proposed an amendment to the maintenance fee provisions of our private plan rules and has scheduled a public hearing for September 2nd. We will be distributing those pre-filed drafts by August 21st, which is tomorrow. That amendment is on track to be effective October 30th of 2025. We're also engaging in some amendments across all our rules, including amendments to implement the neonatal care leave provisions from Senate Bill 25-144, and the amendments from this broader round of rulemaking will become effective on January 1st of 2026. Again, we're going to be sharing more details about submitting public comments and our public rule hearing for those rules as soon as we have any details lined up. From a technology perspective, we do have Release 16 for employers coming up, which updates the annual total employee count language to ensure consistency and clarification. Previously, employers saw options for 10 plus or 9 or fewer employees. When that was updated, employers now see the option for 1 through 9 for their small business. Release 16 did also have an impact to self-employed individuals. Correspondence to the self-employed name change task that I discussed on the previous slide in Release 16 will use the term account rather than organization when a self-employed individual registers in the My Family Plus employer portal. We do have several resources and toolkits to help you through all of your employer obligations, and they're always available on family.colorado.gov. That does include file specifications and file templates for wage reporting, user guides and how-to videos, various tools to help you communicate with your staff, your clients, and others you may serve, and other partners you may have, and also always any newly adopted rules and supplemented guidance is published on our Family Rules and Guidance page. And with that, I'm going to hand over to my friend and colleague Phil Spessart to talk about unemployment insurance.
All right. Thank you, Tracy. And as noted earlier on, my name is Philip Spessart. I am the Division Director for the Unemployment Insurance Program here in the state of Colorado. A quick reminder, while Tracy was telling you they're relatively new, reminder, you all already know this, but that we are a state, quasi-state federal program, obviously funded by you, the employers, at both a federal level and a state level. We provide unemployment insurance benefits to those unemployed through no fault of their own at this point in time, and all of that funding comes from you as employers. Quickly, just to differentiate us a little bit from family there, the Unemployment Insurance Program was created in the Social Security Act We're turning 90 this year, actually, related to providing benefits. Now, what I'm going to do for all the other good stuff you want to hear about the UI division, I'm going to hand it over to one of the folks who really makes the program run here and operate and tries for us to seek efficiencies. And I'm going to pass it on to Branch Manager for Employer Services, Megan Culp. Megan, all yours.
Thanks, Phil, and good morning, everyone. As Phil mentioned, I am the branch manager for our employer services area for the Division of Unemployment Insurance. And I have several updates for you related to the employer administration of the UI program. Recently, we did make an update to our MyUI Employer Plus system to prevent additional changes to employer account activation and liability and qualifying dates. These are the dates that tell us that you have paid the appropriate amount in wages in order to require an unemployment insurance account. We were finding that there were several issues with how rates were being calculated and some other back-end system administration. Employers often would get a little bit confused about which date came first, and so we have adapted the system to monitor this internally. And so for those who do need to conduct this process, reactivate their account, change those dates, we suggest that you call us or preferably submit a contact us request in our MyUI Employer Plus system. So there's information listed here on what we would ask from you when you do submit that request. Employer name, your account number, this is your UI EAN, your federal employer identification number, the date that you reinstated your payroll, and then when you hit that $1,500 gross wage qualification threshold. For the wages for submission, when you have employees in multiple states, next slide there. Thank you. Colorado's unemployment law does allow for you to report multi-state workers. There are several guidelines and requirements within how you report those to the system, and so we encourage you to visit that Wages in Multiple States page for more information on our website. Notably, out-of-state wage credits that are requested by these employers who have somebody move mid-quarter or mid-year from one state to another on a permanent basis will request out-of-state wage credits towards the wage base or the taxable wage base for the wages for Colorado versus what was reported from another state. We do have a new limitation on these effective the second quarter of 2025. So that was just this past quarter that was due the 31st of July. We are only going to be reviewing out-of-state wage credit requests if those wages were reported to Colorado within the last 6 quarters. So the wages that you're asking for the credit on, those have been reported within 6 quarters or more recently. And those wages can be verified in the Interstate Connection Network. This is the ICON system that all states report wages through, or at least they have the interstate wages. And what we do there is validate that the wages that you tell us that were reported, for example, to Texas, are actually reported to Texas, and we can authorize that credit for you. So if those two criteria are not met, if the wages are older, or if we are unable to validate those wages within the ICON system, we will unfortunately be unable to authorize that wage credit moving forward. So these are going to be a notable point here is even though this change was effective Q2 of 25, this also applies to older wages. So the change itself and the look back period is all effective Q2 of 2025 and so current. If you were to submit wages for a prior report, that would be held to that 6 quarters. It's not for Q2 wages and forward, it's effective Q2. Next slide. For just a little bit of awareness, recently Senate Bill 25-242 created what we have termed the UI Program Support Fund. This fund is designed to support all of our technology and program administration needs and not just technology projects. And so as such, we are rebranding it essentially from the Employment and Training Technology Fund to the UI Program Support Fund. So what this will look like to you is essentially just a new label. It's really important to note here that the buckets and the size of those buckets for our support funds is not changing. So the distribution is just going into a new label. It's not going into a new percentage or into an additional distribution. You will see that notably on your 2026 UI rate, which will be available for employers in the MyUI Employer Plus system in late 2025. And then you will receive those rate notices in the mail around that same time to early 2026. And I think we have some resources as well that may have been at the beginning of the UI section. Similar to family, we have several resources available on our website. Super helpful resources such as the MyUI Employer Plus Toolkit and User Guide. We have a lot of great, pretty user-friendly links to guide you based on topics of interest and need. We also have a UI monthly email update. You are welcome to follow the link to sign up to that. That will allow you to receive the most frequent updates on technology changes, system enhancements, additional changes to processes that the team support. And then we also have the quarterly UI employer and TPA survey, which we certainly encourage you to participate in. We do absolutely review these and take the feedback received and implement it as much as we possibly can. So thanks for your time today. I'm going to hand it over to Amy Kingston with the Division of Workers' Compensation.
Thank you so much, Megan. As Megan just said, I am Amy Kingston. I work for the Division of Work Comp. I am the manager of claims and employer programs. A little bit about workers' compensation. So workers' compensation is a program in which if an employee is injured at work, they can receive medical benefits and lost wages while they recover. However, the Division of Work Comp, unlike family or UI, we are actually not the organization that pays benefits. We are the regulatory body. So what does that mean? That means that we ensure that the system is running as smoothly and correctly as possible. We follow up with stakeholders to make sure they are following the rules. We conduct audits of those claims. And we have 5 main stakeholders. We have injured workers, employers, insurers, attorneys, and medical providers. And from those, only the insurance carriers actually pays benefits. So not us, someone else. We do, though, facilitate any disputes that might come up from those 5 different stakeholder groups, and we provide that free of charge. So some of the rules and regulations that are coming up, the division recently adopted HIPAA standards for electronic billing. So electronic billing from providers will be required starting January 1st, 2026. We also create a statute of just the rules that affect workers' compensation. The 2025 Act is available now. If anyone is interested, they can fill out that request for services or come to our offices to pick one up. But typically we mail these out. So they are always a hit with our attorneys. We are having a tech update currently. For the next 2 years, we will be modernizing our system to what we are calling CoComp. This new system will be extremely user-friendly and will allow our stakeholders to actually log in and see their claims live. So if that will be coming soon, it is very exciting, though. If you have any questions, please reach out to our education and outreach group. We also have great resources and toolkits on our website. Some of the new ones are a new Workers' Compensation 101, which is just a simple video to explain how workers' comp works. That is available in English and Spanish. We also have an adjuster training series that is coming out. We only have a few of the lessons currently online, but we will be releasing more as the months go on. But this is directed specifically at adjusters on how do you handle workers' compensation claims within Colorado. And finally, we have some exciting upcoming engagement opportunities. In the last session, House Bill 1300 passed. It's technically known as the Workers' Compensation Benefits Proof of Entitlement, but it's also known as physician choice. This bill was passed, but it actually doesn't come into effect until January 1st, 2028. So in preparation, because in preparation of actually having this enacted, the Division of Work Comp is going to hold some listening sessions to figure out the best policies for the implementation. Those listening sessions will be held on October 8th, the 22nd, and November 5th. If you would like to attend, please go to our website and sign up. We will also be sending out emails. So please join our email list if you would like more information. But we are seeking specifically input and points of view from our stakeholders on how they would like to see this bill implemented and how it could go best for workers within Colorado. We also have a bi-yearly workers' compensation education conference down in Colorado Springs that will be on March 9th to the 11th. This is a great opportunity to network, but also learn a lot about how workers' comp works in Colorado. If you are interested, please click our links or sign up for the conference. I'm going to now turn it over to Christina Rosette with DLSS. Thank you so much.
Thanks, Amy. Hi, my name is Christina Rosette. I'm the Acting Director of the Division of Labor Standards and Statistics. A bit of an overview of what we do. We are responsible for enforcing, providing guidance, and offering compliance assistance on various different labor standards laws in Colorado. The bulk of our work is in wage and hours, so enforcing the minimum wage, payment of overtime, proper deductions, rest and meal breaks, things of that nature. We receive and adjudicate several thousand claims a year related to payment of wages. And that also includes paid sick leave. So separate from, family and other benefits my colleagues have spoken about, the paid sick leave passed by the Healthy Families and Workplaces Act provides 48 hours a year of paid sick leave for various health and personal needs. We also have authority over pay transparency and pay disparity claims, so ensuring pay equality between the sexes, and in terms of transparency, requirements to post salaries or expected pay rates in job postings, limits on the types of questions that can be asked in job applications and employment questions, such as limits on when credit history could be asked about, age, things like that, and disclosures in gig work. So requirements that delivery network companies like Grubhub or transportation network companies like Uber and Lyft provide information to drivers about what their pay for a task will be, and to consumers about what the drivers are paid relative to the overall cost of the gig. We have some authority over labor relations. Much of this falls in the federal sphere with the National Labor Relations Board, but certain private sector union elections we administer, and then public sector employees, organization or unionization and representation election rights we also oversee. Agricultural labor conditions, so protections from heat exposure, requirements about water and shade that apply to farm workers. And finally, retaliation, which are protections against terminations or other actions against employees for asserting all those rights that we enforce. Since that's a lot, sometimes it's also helpful to think about us in terms of related topics that we do not cover. So we don't cover discrimination, harassment, accommodation requests. Those go to the Colorado Civil Rights Division or the Federal Equal Employment Opportunity Commission. And we obviously don't cover benefits like family, unemployment, workers' comp. Those are my other colleagues on the call. That said, we have good relationships with these entities. So if we get questions misdirected to us, we can point people in the right direction. So upcoming things to know for employers: a couple recently enacted laws that I want to update you all about. House Bill 25-1001 just went into effect a couple weeks ago, and it amends the Colorado Wage Act, mostly in terms of enforcement and compliance measures, not as much in terms of the substance of what needs to be done to pay people's wages correctly, but things to note. The definition of employer, who is an employer that can be liable for payment of employee wages, has changed to include certain owners of employers with at least 25% ownership interest. DLSS is now allowed to waive the penalty for failure to pay wages in certain cases in its investigations. We will be publishing violation citations on our website. That's now required under the bill. And there's also fines for misclassifying employees as independent contractors. So that's 25-1001. And the other bill I wanted to update you all about is more specific in terms of who it covers. It's related to direct care employment. And so basically this law is putting into effect some of the recommendations that the Direct Care Workforce Stabilization Board has been considering and working on over the few years that that board has been in operation. Many of these are going to be implemented by healthcare policy and financing, but relevant to DLSS, we have upcoming work with the board and with other entities like HCPF to establish a Know Your Rights training for direct care workers and to help employers track completion of that training by their employees. So more coming soon on that. And another update to know about is an upcoming stakeholder meeting we have for administrative rulemaking, including implementing those laws that I just talked about and various other topics. The meeting this year will be in person on September 4th, and it'll be in the 12th floor conference room at our CDLE offices at 633 17th Street. Because it's in person, we're asking folks to RSVP just so we can get an accurate head count and all of that. And as with other rulemaking proceedings, rather than or in addition to attending in person and making a comment, folks are also welcome to submit written comments. So the link that will be available in the materials will allow you to RSVP, submit a comment, or do both. As I mentioned, topics that we'll talk about at the stakeholder meeting include updates to the rules related to those new laws this year. We'll also be issuing a new rule set about hazardous occupations and investigation procedures under the Colorado Youth Employment Opportunity Act. A new rule set about processes for certain appeals of division decisions. And then, as we do every fall, implementing the upcoming 2026 minimum wage and various numbers that are based off of the minimum wage. Next slide, please. And nice to know, we shared this in a past update, but sharing again to just bring visibility to it. We're excited about it. We have recently updated and renamed our page for labor law guidance and education, which has a bunch of different resources for different ways to get information about the laws that we enforce. So one of our big ones is the info sheets, interpretive notice and formal opinions, which are our notices and explanations of the laws that we enforce. We have a series of 23, some of them have subparts. So, if you want detailed information about how meal breaks work or about how healthy families and workplaces sick leave works, you can start there and get a very thorough breakdown of all the laws that we enforce. We're also building out our series of knowledge sheets, which stands for Knowledge for Workers on Labor Law is Empowering and Drives Good Employment. So these are worker focused, but they can also be just a good kind of snapshot for employers. They're one page. They focus on the topics that are most of interest based on industry. So for example, for restaurant workers, it'll provide information about the tip credit that is specifically relevant to them. And then the newest addition to our guidance is labor law videos. So we have short educational videos about Colorado labor laws. Right now, we're starting out with break time, final pay, impermissible deductions, and looking forward to building out our library over the next years. And if folks have input on like things that are of special interest and relevance, feel free to reach out because we're interested in that feedback. Other notices that are published by DLSS is also available on this page, so it's really a good starting point for anything related to our laws. All right, and then I'm going to pass it back to Cher.
Thank you, Christina. Thank you to all of our division leaders and our subject matter experts who are furiously typing in answers to your questions. Before we move on to additional questions, I'm going to quickly cover oil and public safety. This is one of our regulatory divisions at CDLE. They enforce safety regulations. They also serve as our consumer protection arm for the department. The programs within their oversight include amusement rides and explosives, boilers, conveyances, fuel products, petroleum storage tanks. So they inspect every single gas pump in the state of Colorado, and they inspect for accuracy and quality of fuel. And they also oversee the 811 Commission Underground Damage Prevention Safety Commission. If you are a member of one of these regulated communities, you probably are already receiving one of their bulletins that they regularly publish, and they have a whole host of information on their website as well. Currently, the division, we hit a slide I was going to touch on. The division leadership is now engaged in a statewide series, Keys to Compliance, where they are convening stakeholders of the regulated community to present upcoming rulemaking and take in feedback. So again, that information from the Division of Oil and Public Safety is available on their website. So with that, I think we are doing pretty well getting caught up with all of the questions. I will just reiterate that we did mention at the top of the webinar that this recording, as well as the deck, will be sent out to all registered participants later this week and also posted on our website at cdle.colorado.gov. I'm going to pause for a minute. And Jessica, do we have any comments or questions coming in through YouTube?
We do have one question that just came in from YouTube. This is a family question. So I'm going to toss this over to Evan. The question is, if you pay into family for a year or more, but then become self-employed and haven't opted in, does the fund stay for you to use when you have a baby, or do you lose those funds?
So I think what's helpful to clarify is that the family program doesn't operate like a health savings account or something like that. It's really a social insurance program, and so there are no refunds of premiums. And if someone went from typical employment to self-employment, the way that they would be eligible for benefits would be to elect coverage as a self-employed person. They don't have to. The law makes that optional for self-employed folks, but if they do elect coverage, they have to participate for a minimum of 3 years.
Thank you, Evan. I have a question here for Cher. Monica asks, will there ever be the ability to have one account login for all of the Colorado information versus 3?
Gosh, Monica, that's a good question. That would certainly make sense, wouldn't it? You're engaging with a single department and multiple regulatory agencies. That is absolutely a desired future state. The when and the how we get there is TBD. I know our division leadership on the webinar with me today, and I have been involved in a project to scope what that would look like to have a single sign-on for our employer community. So yes, we are actively discussing that opportunity as a future state, and I hope the future is sooner rather than later. So stay tuned for that and appreciate the question. Any other questions, Jessica?
Yeah, I have another one for you, Evan, for family. The question is, with employee numbers fluctuating for family, how often are you required to update your status throughout the year?
That's a great question. And we count employer size the same way that employer size is counted under the FMLA. It's an interesting technique, but what it does is requires a look back at the previous year, and the number of employees you have are the number of people that you employed during 20 or more weeks. And so your employer size every year for the whole year is essentially a look back at your workforce from the previous year. In that regard, it doesn't fluctuate throughout the year. It only changes once a year. And we require that update during the first quarter. I believe we send out notifications, and that update is required in February of every year.
Thanks, Evan. I have a question here from Kurt. This one is for Tracy Marshall with the family division. The question is there any worry about family being able to be utilized by Coloradans?
Hi, Kurt. Thanks for the question. So from a solvency perspective, we currently have no concerns at all about the fund being sufficient and healthy and able to take care of all Colorado workers if and when they need to utilize it. So no concerns from a financial perspective at this time.
Thank you, Tracy. I have a question here from Haley. I'm going to toss this one to Lindsay within the family division. Megan Culp, this also might be relevant for UI, so you can answer it following Lindsay from the perspective of UI. The question is, if I miss filing for wage withholding for Q2, how can I file online myself for Q2 and make up for it?
Thank you for that question, Haley. You are able to submit wage reports and make premium payments for any open quarters in the My Family Plus employer portal. When you log into your account, you can navigate to the wages and premiums page, and all open quarters will be visible to you there. There are late report penalty and interest fees, but if you call into our call center, then that's something that we can work with you on. And Megan, if you wanted to jump in for UI.
Thanks, Lindsay. Yeah, very similar response, but I appreciate being able to answer for UI as well, since we do have a separate system, all open quarters. And I think that's an important emphasis that Lindsay made as well, that if you are trying to file for a quarter that you know you had wages, but perhaps you don't have an account or it's not considered an open quarter, you may need to reach out to us for support. But the MyUI employer system will show you any past due quarters. And we also will have penalty and interest, which we can work with you on depending on your circumstances.
Thank you, Megan. We have a follow-up question from our YouTube audience. Evan, you had answered this previously. The follow-up question is, if a self-employed worker elects coverage now and participates, will they have funds by May of this year? I'm assuming of next year is what they meant.
If I'm understanding that correctly, if a self-employed person elected coverage today and they were planning on potentially taking leave in May of next year, then yes, they would, assuming that they're making money with their self-employment and paying premiums on that, they would have a wage base upon which to calculate benefits, and it would be a couple of full quarters. So it's a really important point. And so, sort of as a reminder, the way that family always works is that your wages are your benefits are calculated by looking at prior complete quarters. Self-employed folks who think that they may want to utilize some family leave in the future are encouraged to go ahead and elect coverage sooner rather than later, so that whenever they do need to take the leave, they have wages from self-employment represented in some prior completed quarters.
Thanks, Evan. I'm going to toss a question over to Christina Rosette from DLSS. The question's already been answered via chat, but if we could chat about it live, that would be great. The question generically was, how are employers required to inform their staff of their rights Can they simply send a link? Are there other requirements?
Yeah, thank you. So first thing to know is that requirement is applicable to direct care employment only, so not a overall general requirement for employers. For direct care employers, the legislation requires DLSS to work with the direct care board and with healthcare policy and financing to create the training. And we're still kind of working on the mechanics with them. What's likely to happen is that we'll create some way to do some of the modules online and get an automatic certificate from that. So we're exploring ways to make it less burdensome for employers to keep track of that. But requirement to start the training is not in effect for several months. So we're working on the details for those employers, and we'll update our direct care website accordingly when we know more.
You are muted, Jessica.
Thank you, Cher. Sorry about that. I have a new family question that we haven't covered yet. So Evan, I'm going to hand this over to you. Question is, for family, how many days must an employee miss work to file a claim? I have had employees miss 1 to 2 days and then ask about the opportunity to file.
That's a great question, and there is no minimum absence per se in order to file a claim. The one thing I will note is that the statute provides that you have to have an accumulated 8 hours of leave before your leave becomes payable. But that's about it. For example, the safe leave benefit that provides some time off for needs arising from domestic violence or abuse. You can take safe leave to seek legal assistance to address some of the issues arising out of that. That might only take a day or two for that instance. You could certainly file a family claim for a day or two. You might only need a day or two to care for somebody with a serious health condition because somebody else can't care for them for a bit. That would certainly be available as well. So basically, so long as you're meeting the eligibility requirements, there isn't a minimum amount of leave. Again, other than you got to reach that 8 hour threshold before the claim becomes payable.
Thank you, Evan. I'm going to hand this next question over to Megan in UI. The question is, we are a Colorado company and have US employees who work out of the country. If an employee needs to make a UI claim, will the system approve and pay out even though their work was performed in another country? Additionally, can we register an employee from another state into the Colorado UI system?
So a couple questions. The first I'll start with is the out-of-country employment. Essentially, if that is a permanent placement, if they don't maintain a domestic U.S. address or place of residence, typically they may not be covered for unemployment benefits. There are so many nuances to that, and as we like to say, we can't pre-adjudicate a decision on that. And so the recommendation is, of course, to file. Everybody is eligible to file an unemployment claim, and then the facts of their employment situation will determine their eligibility. But typically, if it's a permanent overseas placement, they may not have that eligibility. And I'm sorry, Jessica, can you repeat that second question? Oh, you may have lost it.
It was already cleared out, but Elizabeth has a follow-up question that you can answer
Okay.
next. Her question is, with seasonal employees who submit for unemployment who accepted the job knowing it was seasonal and had an end date, what is needed by the employer to provide supporting documentation to Rebutte?
Okay, sure. So on that one, just respond to our request for fact-finding timely. That's going to be your best bet as an employer. That's your opportunity to provide your input on the separation. And information will come to you via the MyUI Employer Plus portal. We also can send information via mail. These typically have really pretty strict turnaround times, sometimes to the hour, if it's a 48-hour time frame, for example. And so you're going to want to be on the lookout, make sure that the right person has access to that. Go ahead and validate your authorized users in the My Employer Plus system and look for that information to provide that input. Should it get to the point where you have concern about the employee receiving an award of benefits, there is also an appeals process, and the information on that process is provided on the notice of determination when you receive that information in the mail about the claim. So there's a couple options there as an employer to have your feedback heard.
Thanks, Megan. I do want to visit another UI topic that's already been answered, but it will be good for everyone on this call. The question was, the employer misses being able to download the completed reports, and they're requesting that that be a development enhancement, but that is already available to you. And Craig, if you want to go ahead and drop that link into the chat for everyone on the call to see, we have a how-to guide basically on how to do that, and we'll put that link here in the chat so you can all see it. Megan, if there's anything else that you want to add to that, feel free.
Nope.
Okay. All right, I'm going to switch gears to family now. Holly's question is, for exempt employees using intermittent family leave, 2 days per week, are the leave days qualifying a qualifying deduction from their pay, i.e., can we pay for the 3 days per week worked while family pays for the 2 days per week?
I think that's a really excellent question. I think Christina Rosette would also be pretty interested in that question. This is sort of getting to the FLSA guidance parameters, what have you, of what constitutes a salaried employee for purposes of being overtime exempt, and what days can you not pay your salaried employee? What weeks can you reduce their salary and still maintain that classification? To my knowledge, the FLSA has some specific examples of when an employer can pay less than a full salary during a week and maintain that status. Family leave is not expressly one of those. I believe FMLA usage is, and so that gets close. But so that said, and with that sort of general framing of the issue, I think these are going to be, both really fact intensive determinations, and would be something that wouldn't just be a family answer. I think it would also be, a Colorado labor standards answer with regard to that sort of salary exempt status angle. Christina, I don't know if you want to add anything to that.
Yeah, no, thanks, Evan. I think that's right. We in the state generally follow the rules for federal, the same rules as federal DOL follows in terms of deciding what types of exemptions are proper or deductions are proper for someone to still be a salaried employee. For example, deductions based on poor performance aren't permissible if you want to maintain exempt salary status, but certain deductions related to, if an employee is otherwise being paid out through a bona fide healthcare or a PTO plan are. I point to our guidance on salaries and exemptions in our info sheet series. Info is 1 and 1A, and I can provide the link here.
Thanks, Christina. I'm going to move back to UI. Megan, the second half of the question from earlier was, can an employer register an employee from another state into the Colorado UI system?
Yes, thanks, Jessica. Someone else just placed that in the chat as well. Shout out to Tracy for finding that. So The short answer is yes, but there is always an it depends when it comes to unemployment. And that's because we have something called localization requirements and rules that we base off of federal standards. And it basically goes through an entire decision tree of how much work is performed in which state, is it incidental, where the base of operations of the company may be, where the employee's residence is, if it's temporary in nature. So usually what we say is if it's 12 months or longer, we would consider that a permanent placement. And then it's really dependent upon does the employee travel through multiple states to conduct their work? If we use an example of like an airline, typically those employees are reported to their home state where their personal residence exists. So we do have a link on our website. And actually, if I could ask Craig to place that link in the chat as well for localization rules, we have an entire flow chart that can help you make the decision on if your employee needs to be reported to Colorado.
Thanks, Megan, and thanks, Craig, for dropping some links into the chat. We'll also make sure that these links from these common topics get included in our follow-up message that we send out later this week. Okay, I'm going to move back to family. The question is from Joe. When you pay family, you report it as unemployment on 1099-G. Is this pay supposed to be non-taxable? Evan, can you take that?
Sure. I mean, there's quite a bit here, and this intersects with some recent IRS guidance that we have currently a grace period and will be implementing practically in 2026. But the broad stroke of that guidance is that starting in 2026, medical leave, which is leave to care for your own serious health condition, is considered by the IRS to be third-party sick pay, and as such is considered to be subject to both income tax and FICA taxes, but only to the extent that that benefit is attributable to employer contributions. And so in determining whether or not taxes are attributable to employer contributions, we have to look at the employer size. As you know, large employers have an employer share and an employee share. The smaller employers, those with 9 or fewer employees, in addition to our self-employed folks and our local gov opt-in individuals, they only have that employee share. And so we are working on implementing that guidance to make sure that basically employees of small employers and therefore without any sort of benefits attributable to an employer share are not seeing that medical leave taxed. And employees of large employers will see a portion of that medical leave taxed, or at least like withheld under with income tax and FICA withholding as well. A lot is coming on that, but that's the broad strokes of the guidance the IRS issued to the states this year.
I'm going to hand you another question from family. This is what's the word I'm looking for? My mind is drawing a blank. Let me just ask the question. I have an owner who draws a wage but does not actually work in the business. Is he exempt from family?
The most I can say is maybe, because I can't, on the fly with limited facts, adjudicate and tell what the law is with a particular person. But generally, owners who own at least a 25% share of a business will be considered self-employed, and it's an option as to whether or not that self-employed business owner wants to participate in family. If they don't want to participate in family, then they shouldn't remit any premiums associated with the wages or income they receive from that business.
Thanks, Evan. I'm throwing a lot your way. I'm going to try to tackle Dina's question here. This is a question for the family division. And Dina, if I can unmute you, I will try to do that, but let me try to interpret this first. She says, if two employees left, uh, have requested time off and marked it for family, but they also requested personal leave at the same time, um, and use that leave to go to another country. When they came back from their leave, they did not have enough time to, I think, take family leave, so they instead applied for employment. How do we go about this? Dina, there's a lot going on here, so I'm going to try to see if I can unmute you, and if you want to help us out, that would be great. Let me search for you and see if I can.
Can you hear me?
I can. Go ahead and ask your question.
Okay. Yeah. So my question is, so these two employees, they're twins, they're a family, and they asked for a time off. And on the paper, the time of request, they marked it as a family and a personal leave. So they left out of country for 3 weeks, and we have a paper saying if you leaving more than for 1 week, they just started working with us recently, like in May. No, not in May, in February. And we have a paper, and they signed it that we're gonna get them back if we're gonna have enough kids to give them hours, because we had to hire someone for 3 weeks. We cannot leave kids without any teacher. So we had to hire another person. And when they came back, we did not have more kids, to get them full time again. And they applied for unemployment. How that can be? They didn't apply for family, but they applied for unemployment when they came back because we didn't have a full-time hours for them.
Jessica, this might be more of a job attached status question, so I would maybe ask one of our UI SMEs to just quickly explain job attached, and then we can see if we can follow up with Dina afterward.
Okay.
Phil, would you like to speak quickly to job attached?
Sure. If an individual is on unemployment insurance benefits and they have a basically guaranteed return to work date with an employer that's within 16 weeks, they may be able to be job attached to that employer. That means the employer is guaranteeing that they're going to bring that employee back. What that really means is that the individual still must remain able and available for suitable employment. They just don't have to make an active work search during that period of time in which they are job attached. That doesn't mean they can refuse any job that comes their way. So if some suitable employment somehow is offered to them during that period of time and they refuse the suitable employment, that needs to be reviewed by the unemployment insurance office, which could result in a denial of benefits from that point forward. But that is something that people can utilize. As an example, construction industry utilizes that a lot, especially around the winter time, where some of their employees will be off for 1 or 2 weeks due to snow. Those individuals file a job attached unemployment insurance claim, strictly meaning that they're not required to make an active work search during every week.
Thanks, Phil. Dina, it sounds like perhaps your workers did not have a qualifying condition to be eligible for family, but without knowing the specifics, we'd probably need to chat further, but we'll try and follow up with you. We appreciate the question.
Thank you.
Thank you. Well, I think we're about at time. So thank you to our division leadership, to our subject matter experts, to our moderator, Jessica, all the folks managing the chats via YouTube as well. This concludes this quarter's webinar. As I mentioned, we will have our newsletter version of this content delivered in October. All previous webinars and newsletters are available on our website at cdle.colorado.gov. And a recording of this will be available on our website as well and to all registered participants later this week. So with that, thank you so much for spending an hour with us today. We hope we got all of your questions answered. If not, you know how to find us. We have a lot of options to get in touch with us via social media and on our digital channels, including our website. So thank you so much. Have